So let's please, if you will, share with us a little bit about what you focus in your practice. And some context is interesting. People always like to hear the personal journey. So maybe in 5 minutes you can tell us what took you to this point, what interests you, and any things that you want to focus on in the near future. And then we can start talking about the high level view of these content, how content is changing, how it has been regulated, how there are ethical expectations. And then we can talk, have a nice conversation.
Sure. Yeah, and just feel free to jump in, or if I go down a rabbit hole, reel me back in.
Wonderful. Thank you, Ken.
Right. Well, thanks for having me. This is when I read about the article that you're developing. It's something that's near and dear to the work that I do, and it's important to me. And it's an intersection of a lot of different things. It's an intersection of technology, law, society, the law, ethics, societal norms, and all of these things are very important to me and really my background. So back in the day, I was a tech co-founder and then a banking co-founder, which was heavily steeped in technology. I was a Microsoft engineer and a Cisco engineer. So I actually know what the ones and zeros look like. You and I might be on Instagram, and I know what's running Instagram. And it's so interesting to find out that today, this skill set that you've developed doing what you've done with your varied background and that I have really lines up with what's going on today. And what's going on today is this prolific use of social media, media in general. Now we have AI as an overlay. This is a big election year that's coming up. And what I really enjoy doing is looking at these situations and analyzing them. And the way you've laid out your questions and the way that you've laid out the premise of this project is really interesting. So my background, I did technology. I went to USC Gould School of Law. I have an LLM in privacy and cybersecurity. And everything that I've done is very media and tech focused. So I write articles. I have a journal coming out. It used to be the Hastings Law Review. Now it's being renamed to the University of San Francisco. They're going to feature one of my articles on third-party data privacy and the government Fourth Amendment. I've got another one in the Law Review of Asia about the use of the third party doctrine and data, which all relates a lot to social media and big data and things like that. So when I look at what you've put together here, it's very interesting to me because I believe it spans three different discrete areas of law. One of them is constitutional law, and specifically US constitutional law. And if we're really drilling down on that, First Amendment, Fourth Amendment. And First Amendment conversations and Fourth Amendment conversations are very, very different. Most of what you're talking about relates to the First Amendment, and that's the freedom of the press and the freedom of speech and the ability for political candidates to get out there and have protected speech, because there's individual speech, which is highly protected by the constitutional amendment, and then there is commercial speech, which generally doesn't quite have the same protection as an individual's right to speech. Political speech and political ads, which is what we're really talking about today, is is a hybrid, and it's highly protected because, of course, the Constitution is what our democracy is built on, and the ability of people to get elected in a free, apparently a free way, is very interesting. And what's also really interesting about social media today is, yes, big candidates and PACs and parties can spend hundreds of millions or billions of dollars on social media. What's interesting, though, is that the underdog, the independent candidate, or somebody who maybe doesn't have the same cash to put in the game, they can be on that same platform. So in a way, this democratizes speech to a level where before, if you wanted to be a candidate, you had to have a lot of ad spend, you had to have billboards, you had to have lawn signs. So technically, and we know this isn't really the case, technically anybody could have a campaign, and maybe a successful campaign, if they knew how to go viral and how to get followers. So the first prong of our analysis is constitutional law. The next is IP law, intellectual property law. And what you've talked about is, hey, what about deep fakes? What about it's not really the candidate, it's a likeness of the candidate, or if it's not the candidate, it's somebody endorsing either that bill or that proposition or the county tax. Because remember, there are free AI platforms and free social media platforms. So we all think big picture presidential elections. There's little cities with populations of 7,000 people, and there could be social media campaigns, and there could be deep fake caricatures of people saying things on social media. So we need to be considering that as we think of this analysis of, yes, we're thinking of the big 2024 election. There's lots of other things going on this year and in future elections that are impacted. The next piece of this is privacy law, because social media, the premise of social media is that people, campaigns, PACs, political consultants, candidates can target audiences. And they can target audiences based on socioeconomic status, based on psychographics, other demographics. So then the question is this privacy thing, this information that we, when we get these free apps, we consent for these platforms to know who we are, where we live, where we had breakfast that morning, who our friends are, what our buying habits are. When we're opting into these platforms and getting these free services that aren't really free, we're also getting all of our data out there. So now the question is, a political campaign could use a deep fake, they could use AI, and they could use private data about us and then target messages to us. That's a word salad. You want me to drill down on any of that?
No, this is amazing.
Okay,
I'm very happy to hear this, framing, and I'm with you.
great.
So far, great points like uh the fact that we used to think very big, like we think about Trump and we think about Biden, deep fakes, but the fact that you're bringing it to, no, we can use this for a county of 100,000 people and fool, for if I want to be candid, or what could happen, fool 20,000 people. So it's like and it could be about a bill, it could be about misinformation about something very specific, and that also affects our way of life. So, and that's a great point. And then the three pillars, thanks for clarifying that. It's a great framing as well. No, I think we're doing great, so please
Good.
continue.
Just thinking about our meeting and preparing some notes, I feel like it would be remiss for us not to talk about Cambridge Analytica, which was huge. I mean, it made news, there were raids, people got in trouble, there were hearings, and there have even been documentaries made about Cambridge Analytica. And the thing to consider is that Cambridge Analytica happened in 2014, 2015, 2016. Imagine that's almost 8 to 10-year-old technology where AI didn't really have as much of a play as it does today. So take the impact that Cambridge Analytica had on the Trump campaign or on Brexit, and the needles that it moved to change people's minds and persuade them and use rhetoric. Now add AI on top of that. AI in two ways, because actually AI in three ways. One thing we know about AI is that it's incredibly efficient and incredibly accurate with the way that it sorts data and looks at trends. So already what they were doing at Cambridge Analytica was good. There was a lot of manual computation and regression analysis, things like that. Now AI will do that in milliseconds with a high degree of accuracy, a better degree of accuracy than ever. So we've got smarter, faster. Then we talk about what I call brute force or brute strength. And that is that, you had Brittany Kaiser and a couple other people at Cambridge Analytica that were running those campaigns and doing things. They were physically loading things, physically testing things. Now take machine learning and take that you can exponentially test things and push things out and create content. And then the question of the content that it's creating is it taking a speech that a candidate did and slicing it up into micro content, or is it taking not the real likeness, not the, we call it nil, name, image, and likeness? Is it not taking the real nil of that candidate or of that endorser? So is it creating deep fakes, whether they're authorized or not? Is it creating these deep fakes to get out more messages? So when you take the power of AI across these three big things, fast, efficient, accurate, the ability to create lots and lots of content, and then the ability to create fake content, this is a much different game than 2016 election or Brexit. And it's really interesting because a lot of people don't know this. Brittany Kaiser, who was kind of the brain trust behind the Trump election, what a lot of people don't know is that she got paid by Cambridge Analytica a pretty good amount of money. When she was a teenager, the way she figured all this out is there was a campaign for the 2008 presidential election, and she was an intern while she was in ninth or 10th grade helping do Facebook ads for Barack Obama. And when we go back and we look at the history there, some of his campaigns, a lot of John McCain was out there getting his $2,600 per person, getting all the PAC money. One of the things that President Obama was really well known for was, hey, do you have $5? Do you have $10? So these are things that I think need to be understood in the history of where we are today. Is that if we go back to 8, 10 years ago, we're really taking Cambridge Analytica to the power of 10 or the power of 100 or 1,000. So
In context, we have like the same understanding that the Obama election was historic in the sense that it was the first social media driven election, and then the Trump election was an animal in itself. So this is great context.
well,
And
even what happened, and I'm not going to go too deep into it, but even what happened in January 6th and
yeah,
where social media plays into that, and of course, X, the former Twitter, and all those kinds of things. One of the things that you wanted to know was, how does GDPR, CCPA, different constitutional amendments,
but
maybe.
yeah, I think that the one good question that I could ask here is we got a lot of international readers, so many people are familiar with the First Amendment, the right to free speech. You already mentioned that there's some nuance to it. The Fourth Amendment is the unreasonable searches. So if you could please start there, and we can go into the implications of international regulation, some state regulation, because for instance, California, where we are, has a very similar regulation to the GDP R, and then how the different levels of hierarchy play into the decision making process of a company or a campaign to invest into social media influencer content marketing practices.
Sure. Starting with the Fourth Amendment, and a lot of people are familiar with it, unreasonable search and seizure. There's really two pieces to the Fourth Amendment, and one of them is search and seizure, and the other piece is a reasonable expectation of privacy. And it goes hand in hand with search, although it's a little bit different as well. And what we need to remember when we're talking about the Constitution, it applies to government actors, not private actors. So, for example, a social media platform isn't bound, they're protected by the First Amendment, and they might have some interconnectivity with the Fourth Amendment. People can't sue a private corporation for a First Amendment or Fourth Amendment violation generally. There are some amendments with relation to labor, indentured servitude, where people might be able to raise a constitutional claim, but generally 99.9% of the time when we're talking about constitutional protection, it's against a government. So against government suppression or government action.
In this case, there's been some conversation around when Elon Musk bought Twitter. There was like this the X files or the Twitter files, and then the controversy there was we've got specific requests from the government both the Trump and the Biden administrations to remove content, or to I really don't remember if there was promoting content, but I think there was. I'll dig deeper for the piece, but I understand what you're saying. Maybe you can touch on that specific approach in terms of the First Amendment, and then we can talk about the Fourth Amendment.
Sure. By the way, this could also be another article too when we talk about platforms.
Sure.
So when we talk about X/Twitter, when we talk about Meta, when we talk about TikTok, there's some very nuanced things that are going on there. So what's interesting is that the platform can allege constitutional protection against the government. So when the government comes and makes requests, they can exercise their constitutional rights. So companies and citizens, corporations are considered citizens. So a corporation can allege constitutional protection. So they can say, hey, under the First Amendment, freedom of speech, under the Fourth Amendment, unreasonable search and seizure. That being said, there have been laws enacted by Congress. There have been laws upheld by SCOTUS, Supreme Court of the United States. And where things get interesting, and I think when we're talking about elections, this tangent applies. When we start talking about national security, there are some exceptions. So, for example, whether it's the United States and the Constitution, whether it's Europe and the European Union, or even UK, or South America, LATAM, generally there's going to be some constitutional protections against search and seizure. There's going to be some constitutional protections about a reasonable expectation of privacy. Where it's pretty clear in almost every country in the world is if there's a question of national security or imminent harm to the public, then we would say all bets are off, meaning the government can get this access. The other thing to understand is that just because there's a
Is that
constitution,
because of precedents, or is that because of a general understanding of the law, or is this like something that the Supreme Court, in particular, the particular case of the United States, they already came up with a ruling?
so it's interesting. I actually just researched, so I'm very familiar with US. And then for this journal article that's going to get published in Law Asia in a couple months, I researched and I compared and contrasted Europe, Asia, Singapore, United States. And generally, with exceptions of, and I hope we're not going to get in trouble here, with the exceptions of Russia, China, Venezuela, where there's arguably an oligarchy or a dictatorship, where it's not a democracy. Every country where there's a democracy follows a general rough set of guidelines. People should have an expectation of privacy. People should be safe from unreasonable search and seizure. The First Amendment that we have in the United States and the freedom of the press is a little more unique to the U.S. and that goes back to the King and all the history that we know about the Revolutionary War and those kinds of things. So as we start looking at the global perspective, generally the court, the legislature, even the ruler of a country will apply a balancing test. And this is what the Supreme Court talks about a lot. When you actually look at their rulings and you start going through it, they talk about prongs and tests and balance and on balance. And what they're constantly balancing with First Amendment and especially Fourth Amendment cases is what's the need to protect the public balanced against the need of an individual's right to privacy or free from unreasonable search and seizure. The other thing to remember, because some people start to think, hey, I'm protected, they can't come search me. We're talking about without a search warrant. If law enforcement agencies, US or other global ones that essentially follow the idea of democracy and they follow the idea of search warrants, it's not that difficult to get a search warrant.
Yeah.
If there's probable cause and there's a wrongdoing believed, and I know we're kind of veering off a little bit here, but just as we're talking about Fourth Amendment protections, Fourth Amendment doesn't mean that the government can't look under the hood.
Yeah.
It just means generally that they need a search warrant. The burden of showing of cause to get a search warrant is not unreasonably high. If a law enforcement agency has reason to believe something is going on, including, hey, this might be a matter of national security, they can usually, there are judges who are awake at night where warrants can be issued.
Yeah.
So I want to be thoughtful there, because sometimes people believe, hey, the government can't look or can't do anything. And how this connects to the political campaigns and the use of social media and AI and deep fakes is that we've got to understand that in addition to these platforms, in addition to the candidates, there is government intervention. And we do have regulations in the United States. The FTC, for example, has got guidelines around endorsements. By the way, whether it's a political endorsement or any kind of endorsement, the FTC has requirements around that. And I know you want to get into that, so we could talk about that a little bit later.
So going back to the First Amendment is clear. Fourth Amendment also very interesting. Let's move on.
I've got a couple points that might be helpful for you.
Thank you.
This was kind of a compare and contrast of GDPR, CCPA, First Amendment, and Fourth Amendment. So GDPR and CCPA are the more stringent, and those have been in place for several years now. GDPR was early to it, and then CCPA came in 2020. And there are some different thresholds and levels of compliance. GDPR is pretty strict. There's almost every website, every platform needs to follow GDPR. There were some thresholds discussed for company sizes and revenues and things like that. That's all shifted in the last couple of years. If you're out there on the digital footprint with an app, with a website, with email marketing, you've got to follow these very stringent requirements. And the requirements are around a couple things. It's part of it's around permission and not bothering people. And then the other part is privacy, which, it's funny, goes back to kind of the Fourth Amendment in the United States, and then over in Europe, their expectations around privacy. Hey, this is my data. This is my private information. This is where I've been. This is what I've done. These are meals that I've eaten, hotels that I've stayed at. And having that information out there is concerning to a lot of people. What's interesting about GDPR and CCPA is that if those regulations restrict the data that platforms and big data companies can retain on users, we all know that to have effective campaigns and political campaigns or marketing campaigns, we want to target users. Now we have a challenge though. If we're telling the companies you can't amass this data, then me as a buyer of social media ads and boosting and wanting to run all these posts, I might not be able to target the same audiences that I could before. If we're in jurisdictions that are CCPA or GDPR, I might not be getting the right data, and I might not be making good ad buys with, whether it's an endorsement, whether it's the political candidate, or whether it's deep fakes of those. We're now limited there. So we've got the GDPR and CCPA and those regulations, which now inhibit the platforms and the ability to reach target audiences. We talked about the First Amendment, which really protects free speech and also protects platforms in terms of there's Section 230, and then there's a recent case of Gonzalez v. Google, which was really Gonzalez v. YouTube, and that was the ISIS beheading, and the family sued YouTube/Google, and the court upheld, as they have over the last 5 or 6 years, is that platforms are considered publishers, and they're generally held free from prosecution as long as they follow some guidelines. Are there proper takedown? And this applies to deep fakes. And it's very interesting how this is all connected, because it applies to the deep fakes, it applies to political ads, it applies to campaigns. So is this true? is the message inciting a riot, which you're not allowed to do, as we know from January 6th and other times? Is it hate speech? Those kinds of things. As long as the platform can show, hey, you can flag content, hey, there are some moderation procedures here, then the platforms can be held not liable. And it's really down to the people posting. And in this case, if people are creating deep fakes, the liability lies on them. Question I have is, what if there's a piece of software that markets itself for being able to create deep fakes? Are they now liable because they've created this technology that allows people to spoof people? And of course, if you look at their terms of services and the EULAs, the end user license agreements, they say, hey, we're not liable. I have a feeling that we're going to see some cases in court in a couple of years where not just the people creating the content are being sued. I think some of these tech software, not the platforms, but the tech software that enables the deep fakes will probably get named. And then the question is, if you make guns, can you be liable for people using the guns? Or like, hey, we just make tools. The way people use them is another thing.
I have a follow-up here
Yeah.
because this is, I think you're starting to strike the nerve. Today and tomorrow there's this whole Assange uh decision making for the extradition from the United Kingdom to the United States.
Yep.
You mentioned that perhaps the main criteria for government agencies to make a decision that could possibly be or that affects First and Fourth Amendment is national security. So it's clear one understands why Assange, through WikiLeaks, that was acting as a publisher, is being, in prison for so many years. It's because it was related to national security. And back to your point, we're talking about deep fakes, but it's not just deep fakes. It's also misleading articles, either because of lack of information or context or because they're purposely misleading, misinformation, disinformation. This is going to be the name of the game 2024, 2025. So the point at which the government makes a decision, this is a national security issue or could be a national security issue, where you talked about riots, you talked about incitement of violence, but there might be a a, a blurry point, that there's clear incitement of violence, there's clearly a national security threat, but that line is drawn by judges, probably in the United States, driven by media opinion and by public opinion. So, and then you're talking about, yeah, the deep fakes. Who has the responsibility? The publisher, the people creating the tools, the people paying for these content. I see how it's messy, it's difficult, and it's not a simple solution, but we're definitely getting there. I would say that my question was the blurriness of what becomes a national security interest, because even by swaying public opinion, let's say guns, which is, such an important and deep topic, not just in the United States but globally. If certain information um makes, like spikes the purchase of guns in the United States, which I think happened last year. There was, in the last 2 years, there was a spike in gun purchases in the United States. And there could be a point be made about it, being driven by social media information. So it's not a deep fake, but it's information that it's published, redistributed, and that perhaps, a judge or somebody could make the argument that goes against national security. So, any thoughts there? Could you guide us into what questions to ask, where to look at?
Mm-hmm.
In the end, these are big topics, but remember that the purpose of the article is helping business owners, campaign managers, marketers, creators understand what's the risk that they're taking when they're receiving money or not receiving money to endorse a political position, and how that's related to when we do that because a company wants to promote a product.
Mhm.
So any comments on that could be
Yeah,
very.
I there's a couple, and I want to drill into your question in a minute. When we talk about Assange or Snowden, for example, and we talk about the threat to national security, some people will argue, "Hey, that was so 5 years ago, or that was so 7 years ago." Uh, the challenge is the information that they shared was so profound and disrupted so many things that impacted national security that even if today maybe they don't pose a threat to national security, there needs to be punitive measures so that other people don't do the same things.
Setting
And
an example.
arguably, they both say, "Hey, we were doing this for the greater good." There are things happening at levels of government in all countries, whether it's the United States or LATAM or Europe or Asia, whether it's democracies or dictatorships. There are things happening way above our pay grade that we don't know about, we probably should know about, and it doesn't mean that we just throw everything out on the table. I think Assange and Snowden probably could have accomplished some things that they needed to accomplish without putting everything on the table, because it jeopardized national security, it jeopardized people's lives, it jeopardized a lot of ongoing investigations. And generally, and just so it's out there, I'm supportive of the government being able to use data that is accumulated. I do think AI could be used in an unbiased way to filter and look for signals across that data. I think the world could be a safer place using third party data, using this information that all the platforms are collecting, knowing who's purchasing fertilizer, knowing who's purchasing AR-15s, and there being some signals. And when the signal pops up, maybe someone gets a home visit. Maybe somebody goes and does a door knock, and hey, are you doing okay? We're just in the neighborhood checking on it. And maybe some terrorist attacks, domestic terrorist attacks, could be avoided that way. And that's what's interesting, because that supports the idea of data collection and then the government being able to use it. So getting to your question of really kind of getting the what could business owners do? What should they do? And let's talk about could, and then should, I think, is a framework that people make their own decision. What they could do is first understand the legal consequences of what they're doing. And when we're talking about legal consequences, there's government consequences and civil consequences. So we're talking about deep fakes, and let's talk about name, image, likeness, voice, video, photographs, audio. Let's talk about a real person and what they really say that's been licensed and authorized. Let's talk about an avatar fake AI created that's been authorized and approved. And then let's talk about the deep fake that nobody said yes to. If you're a business owner and you have any assets and you have a reputation, I highly encourage people not to go to door number 3, which is the deep fakes. There's enough ways to do well by doing good in the first two. Either talking to people, getting the real people, getting good clips, and or getting their authorization. And say, go ahead.
This is excellent
Oh,
because it gives me the I can now ask precisely about the difference between political campaigns that tend to be a little dirtier than businesses, of course. I'm generalizing, but this is precisely an interesting point where we can talk about the contrast between a political campaign and a business. But please go on. I'm with you. Uh, there's where you get the permission, where you get the permission, but person.
generated.
Yes. So this is excellent because the reason why I interrupted you here is because I can see, for instance, a meme. Memes are so powerful, right? and we've seen memes out there where it's not pretty much it could be a deep fake, or it could be just an AI generated video of, Trump dancing, Obama, doing Biden falling, stuff like this. And it actually makes a difference, and it affects public opinion. It could affect votes. um and I'm thinking that the hypothesis, and I'm willing for it to be rejected, is that a company is going to get a stricter and probably more robust, um what's the word that I'm using, analysis or evaluation or jurisdiction, like, than a political campaign, especially if the political campaign, if it's one of those, activists that are being paid by the pack, but are not disclosing that they're paid by a pack. So that's awesome if we can,
Yeah. So we're really into First Amendment here, and it goes to what I was sharing earlier, that there's some different levels of protected speech. And when we say protected speech, protected by the First Amendment, the freedom of speech, the freedom of the press, the freedom to assemble. And we know that at the very core, the most protected form of speech is an individual in the United States, an individual expressing their own beliefs, whether that's on a courthouse step, whether it's on social media, whether it's in a newspaper, a podcast, radio station. So we know that that is hallowed and highly protected. We know that commercial speech, meaning speech to sell things, we know that that has some level of protection, although not as much protection as the personal. And then wedged in between and very, very close to the individual's right to free speech is political campaigns. So as we're applying, and you said, are there different standards or different guidelines when a company is being looked at versus a person versus a candidate? Applying that framework of, okay, were you a person exercising your free speech? You probably get a pass, unless it was hate speech, unless it was lying. So if it was true, if it wasn't hate speech, if you weren't inciting people to a riot, if you don't shout fire in a crowded theater, you're probably protected. If it's commercial, was it reasonable? Was it, non-disparaging? Was
Use
it
representation, fake advertising, stuff like that.
exactly? And then the political candidate, were you furthering the cause of this group that you're affiliated with, or this campaign that you're affiliated with? So the analysis is going to really rest on what type of speech that was. And generally for companies, if you're involved in a political campaign, my advice is disclose, be transparent, be ethical. And people are used to saying, paid endorsement. And it can be in small print. You don't have to flash it. It doesn't have to be the premise of your story or your hook. Be sure it's disclosed and that people know that, hey, this is a paid influencer. It's a paid endorsement.
Yeah, I wanted to make the nuance there, that we talk about business owners, but then creators and influencers are effectively being evaluated as businesses, right? When they and
Yes, they are, because then it's commercial speech. And here's another tip: is that there's no loneliness in politics. There's a lot of people who have positions and sides. So to the extent that influencers can be retained, or can come with an endorsement that's not paid, of course that's I'm going to call it a pass, as long as they fulfill the requirements of what that protected speech is. So for example, there were plenty of people in past presidential campaigns or past local campaigns who believed, they either believed in a candidate or they really didn't like the other candidate, and for no money they said things. If you're going to put money on the table, that's okay, especially in the United States, we're a capitalistic society. Just be transparent with it, And that's the right thing to do. There's no right way to do the wrong thing. And I think this is where these ethical dilemmas come into play. And when you were saying is okay, so talk about kind of political, political ad spend, political money, versus maybe companies selling products. And I teach this in the marketing classes that I teach either at the University of California or University of Southern California, is that at the end of the day, it's all rhetoric, it's persuasion. And you're getting people, you want to change their attitude to change their behavior. So if you're changing attitudes and changing behaviors, if you want to vote, that's a political campaign. And you don't want their money, you don't want them to buy your skin cream. You want them to vote for your candidate or vote for your proposition or vote for the bond measure to build new basketball courts or something like that. When we go into the commercial world, that call to action is getting people to buy. The process is the same, and I argue that the ethics and the transparency should be the same. If it's an influencer doing it out of the goodness of their heart, great. And you know what? Use that and emphasize that. I'm not getting paid for this. I feel so strongly about this that I'm declaring this. And if it's paid, disclose it. It doesn't have to be a big part of it. It can be a very small part of the ad, or down in the lower left hand corner. Disclose who the pack is, disclose where the money came from, and disclose if the influencer is paid. And I don't want to say that's your get out of jail free card. That goes a long way in a legal liability analysis.
Oh, so it's not enough to disclose it? That's something that I didn't know.
Well, in the United States and especially in California, everybody gets sued. If you have a defense is another question, but could you be in that lawsuit? Was there something, because there's defamation and slander. There's also a thing called false light. Did you
False what, excuse me?
false light, Light?
Thank you.
Did you paint someone in a picture slightly different than who they are? There's
Ooh,
other standards of if people are public figures or not. So public figures, the burden of proof and the burden of showing damages is much higher than if it's a regular person. So if it's you or me and someone defames us, then the burden of proof is higher. If it's someone who's a public figure who's kind of out there in the public eye, then there's a different standard, a different balancing test applied in those kinds of legal analysis.
is it
So
tougher for them?
what's that?
Is it tougher for to prove remind me the light, the
So there's false light, and then there's slander, and there's libel, and there's different levels. It's a rubric based on who you are. Are you a politician, political figure? Are you a celebrity? Are you a regular person? And then what were the things said? So there's these different analyses. Essentially, if you think about it, candidates are going to mudsling. They're going to say bad things about each other. So they have to have thicker skin than if it was you or me and someone said something about us and maybe we lost our job, or,
right.
something
That
as
you explained it very well. That, and I
yeah,
understand that. Okay.
yeah. And again, I know we're kind of getting a little off topic in terms of what the article's about. I think it's good to have a little background, because when we go to these endorsements and when we go to these people, whether it's the real person, whether it's authorized generative person, or whether it's deep fake, what was said, is it true, is there analysis? If it's not true, is there an exposure on things? So that's part one. Part two is the message true? So is it the true person? Is it really what they said? And then is the message that was created or generated, or the way that it was portrayed, was it taken out of context? Was it put in a false light? Did they misquote people? And we know this. Politicians are misquoted all the time, and they're not suing all the newspapers over these kinds of things, because there's a lot of mudslinging. And hey, if you want to be in those atmospheres and doing it, you have to have a thick skin to do that. So there's more protections for the humble folk. So I think that's an important differentiation there. And as we're talking about these deep fakes, again, I really encourage people, your readers, people who are in business to really stay away from those, because there's just so many. There's liability for intellectual property infringement, name, image, likeness, copyright, maybe trademark, who knows what, all the different things. There might be some liability for defamation. And I don't want to give anyone a free pass. You mentioned memes before. There are some defenses to some of these claims, and that would be parody. If it was just so
Fair
obviously,
use,
what's that?
which is part of fair use, right?
It is. And even back in the old days, there was Larry Flint and Jerry Falwell, and there was a cartoon, and it was just so preposterous that, hey, this is clearly parody. And by the way, there's a nuance between in intellectual property law between parody and satire.
Okay.
Parody is fair use, and satire is not. So
Oh,
the
really?
reason I'm sharing this for your viewers and readers is, don't think just because you made it funny, or because you put horns on somebody and they know it's not really the character and they said something ridiculous, it's not a free pass. It may, I've got a boogie in about 2 minutes, but I can follow up with you on email too. It might help, and it might be a defense for things, but in general, parody could help. Again, if we're talking, if your audience is business people, doing the right thing, being transparent, ethics. If we really think about it, there's the law, there's ethics, and there's societal norms. And businesses have stakeholders, and those stakeholders can opt in or opt out at any time with you. And it's not really their understanding of the law is, who knows. Their understanding of ethics is okay. Their understanding of what they think is good, or were you opaque? Did you lie? Did you cover up? And we know this cancel culture now is huge. So the backfire potential of this is really what I think could be another part of your article of, hey, even if you can do these things, maybe even if legally it's okay and ethically it's borderline, when we get into the societal norms, if you do something that violates people's expectations of your brand or your company or your endorsement, it's gonna it's not going to be worth any amount of money that you got paid to run that campaign.